The bold capture of Venezuela's president by the United States is being celebrated by many within Venezuela, as well as the diaspora worldwide. But the operation is raising a number of questions, including its legality. U.S. constitutional law expert and historian Joshua Kastenberg joins us now for more analysis. Joshua, thanks so much for speaking with us today.
Thank you for having me on.
All right, so this operation has really gone against Trump's national security strategy, which basically discourages direct intervention to achieve its goal of a well-governed Western Hemisphere. How is the administration explaining and really defending its reasons for capturing a foreign leader?
Well, their explanations haven't really been on the basis of law or constitutional law so much as they have been on the basis of policy, of what's good for the United States in their own view, or what's good for, the world in their own view. But in terms of what's legal about this, they've had sort of a shifting narrative. And so we're left asking, well, what is the legal justification, and does the rule of law really matter in this instance or any other?
Well, when it comes to using military force, does the U.S. Congress need to be involved in order to vote on it and to help make a decision? Or are there extenuating circumstances, such as, let's say, deposing a dictator, where the president can actually make the final call?
Well, I know there are those in the Republican Party who've claimed that Article 2 of the Constitution that vests the president as chief executor of the laws and the commander in chief of the military doesn't need Congress. But that's not the way the Constitution was created. The Constitution was created to put the biggest constraints possible on the use of military force, both domestically and abroad, which is why Congress is specifically vested with the authority to declare war, among other things. Now, since World War II, there haven't been any real declarations of war. There have been Security Council statements by the United Nations. There have been funding authorizations and authorizations to use military force, but all of that was absent in this instance. And so what the administration is sort of migrating to is that the indictment that was achieved or obtained against the Maduros in the United States District for the Southern District of New York justifies the capture of Maduro, and they're going to simply use the military as an ancillary to do it. The problem with that, of course, as anyone around the world who studies the law, just not U.S. constitutional law, but international law, has to recognize is the United States invaded the sovereign territory of a foreign nation and snatched a foreign nation's leader that's represented at the United Nations. So we're not talking about a recent leader that took over as a result of a military coup or something like that. And that's what really shatters the norms of international law. It also, because it's used the military, and the military is funded by the taxpayers, it also skirted what Congress's role should have been all along, which was to eventually authorize the use of military force through the power of the legislative branch. But that was sidestepped too.
So, Joshua, are there penalties then that the U.S. government, that Trump, that the defense secretary could face for this operation, for capturing a foreign leader?
Well, the United States Supreme Court gave President Trump and every future president a rare gift that is not embedded in constitutional law in the summer of 2024 in the case of Trump versus United States. Because this is an official presidential act, I would argue that he is immune from any U.S. criminal sanctions. The individuals who are operating underneath him, like the Secretary of Defense, the Secretary of State, and military personnel, well, the president can simply pardon them, and that makes them immune from any, federal criminal statute. And that's all we're dealing with here is the federal law. So we're left with international sanctions. I'm reminded of this 19th century imperial prime minister in, the United Kingdom, Palmerston, who, after the Royal Navy bombarded the port of Athens because of an overdue bank loan, basically said, the British can do whatever they want around the world because they have the power to do it. And so whatever enforcement mechanisms can be made against the administration for this decision are going to be, in my mind, purely theoretical.
All right, now the charges that Maduro is facing, Joshua, are weapons charges, drug charges, and they're in New York. So, New York State, are these charges that can stick based on how Maduro was captured?
Well, the United States Supreme Court again gave the administration a gift in a prior decision that long predates this administration called United States versus Alvarez Macain. And the customary view of law was in order to get a foreigner into U.S. courts, if there were extradition treaties and extradition capabilities, you had to go through um, those processes of diplomacy with a foreign government. And that goes back to an American view of international law set up by Secretary of State Daniel Webster in the 1830s. But with Alvarez Macain, he was a doctor and he was in Mexico, and the DEA, or Drug Enforcement Administration, just simply crossed the border and kidnapped him. His argument was the U.S. had no jurisdiction over him because he was obtained in violation of both domestic and international law. And what the U.S. Supreme Court decided was that that principle of international law is merely agreements between foreign countries and the United States and vests no rights in individuals. And that's a significant departure, that theory of international law, from what you have in Canada and our European allies, or our allies in Japan and South Korea. The democracies of the world still believe that extradition treaties have to be complied with. In this particular case, Maduro's attorneys may argue he has some kind of immunity because he's a foreign head of state. But I think the U.S. courts now, in the wake of, Trump versus United States and United States versus Alvarez Macain so many years ago, are going to say, no, those are just international law theories and they vest no rights in individuals. So I suspect there will be a trial. Now, I think the biggest difficulty in terms of prosecuting Maduro is the Constitution vests in every defendant a right to full discovery of the government's evidence, not just the evidence they're going to use against Maduro, but all evidence that they have that's related to the case, including exculpatory evidence. When you think about evidence that's been collected by the CIA and other intelligence agencies that are classified, well, if the courts are going to follow the Sixth Amendment of the Constitution, they're going to have to supply that evidence to the defense counsel. And that's where the real fight is going to be in this case.
All right, it'll be interesting to see what happens. Joshua, that's all the time we have, but thank you so much for shedding light on this complex topic. We appreciate it.
Well, thank you very much.
That is U.S. constitutional law expert and historian Joshua Kastenberg.